Hi, Bill Henshaw here again for the Constitutional Channel. This is close to our 30th video now, I think. And I've got an interesting one today, which I'm going to title, Competent or Not. This is a real problem for the system because a lot goes on here. And as I've said in earlier videos, and we're going to follow up on it, with the ratification, quote-unquote, of the 14th War Amendment, quote-unquote, the position has changed where government now, instead of realizing that the relationship between citizens and government was principal and agent, now they think it's guardian and ward. If that's the case, and we're wards, I think we have to be per se considered to be quote-unquote incompetent. This shows up particularly in the area when you get into one of their quote-unquote criminal courts and you decide you want to go it alone and not use their state bar license counsel, and with very good reason not to do it. This is going to win us a lot of cases. But in California, they think they can hold a hearing, a secret hearing, not ex parte, because in theory you're there, but you don't dare open your mouth for fear of giving them jurisdiction. Cases People v. Marsden, 2 Cal 3rd, 118, Marsden. A secret hearing on the issue of your competence to proceed what they call pro se, acting as your own attorney. No, Judge, that's not what I'm doing. I'm here in proprietary persona, sui juris, acting on my own behalf. I'm fully entitled to do that, and you should know it. But this is what they think, and you have to get their permission to appear in their quote-unquote court. This is jurisdictional, and they have a sworn duty to tell you that right up front so you know what the situation is, but they never do it. Now, this Marsden case is an offshoot of the Faretta case, Faretta versus California, 422 U.S. 806, where the Supreme Court of the United States came to a similar conclusion and reversed a conviction on the grounds they should have allowed Faretta to appear on his own behalf. Bunch of BS. Now, that's an infamous decision. I mean, you want an infamous one, you're looking at one right there. Not Dred Scott. This one. Buck v. Bell, 274 U.S. 200. It's a case for another video, but that's another infamous case, not related to counsel. So you wonder, if we're not competent to go into their courts and proceed on our own behalf, answer this question then. How can we possibly be competent to form the requisite intent to commit criminal acts? That's under Penal Code Section 26. We must be idiots, and therefore they'd be mandated to dismiss the case. They can't prove it. And as ludicrous as that sounds, trust me, it's about as bad as it is. And by the way, I have on occasion been around the quote-unquote courthouses, which often double as polling places, and I haven't noticed that anybody going into the polling booth to cast their vote has been subjected to any competency tests of late. So they're presuming there, on the one hand, you're competent, and yet when you get into one of their courts, directly opposite. Which way is it? I mean, just the thoughts. Then, of course, you go in to vote for their elections, you got to realize that since none of them are authorized by the Constitution, especially if it's the territory that you're in, not a state, and I can prove it, then with those elections, they don't exist, and it doesn't matter whether you're competent or not because the elections don't count. Another major issue I'm going to try to have before the Supreme Court in this upcoming term in 2015. So just some food for thought here to get you thinking in the right mindset when you walk in there. Which way is it, Judge? Am I or am I not? If I am competent, I'm out of here because you don't have jurisdiction. If I'm incompetent, you can't convict me because I don't have the ability to, commit the intent to commit the crime. So I don't care which way they want to go here. It's a tough one. Thank you.